Hi, this is Dr. A with Chapter 11 on Healthcare Law. This is from the 5th edition of Basics of the U.S. Healthcare System. This is the third lesson, and we're going to look at employment-related legislation, discrimination, Civil Rights Act, etc. So let's start with the Civil Rights Act of 1964, also known as Title VII. So this landmark act prohibits discrimination based on race, sex, color, religion, and national origin. Sexual harassment issues also fall under this act. So several court decisions indicate that repeated suggestive joke-telling and lewd photos on display can be legally considered to be a hostile work environment, so be careful what you say. In the healthcare industry, nurses sometimes experience sexual harassment from colleagues, from physicians, from patients. There might also be discrimination against LGBTQ individuals. And so, again, really be careful of your behavior personally, but also be aware that, for example, it is not okay for a patient to, grope somebody or to grab, breasts or do things like that. It's just not okay. So things like that can be reported. And, there are, a lot of things that can happen in a hospital between different nurses or nurses and physicians and things, and these can be, again, considered sexual harassment, and people can even be fired over it, especially if one person complains about it. So let's talk about LGBTQ discrimination claims. So examples of these related claims that the EEOC views as unlawful sex discrimination include, failing to hire an applicant because she's a transgender woman, for example. Firing an employee because he is planning or has made a gender transition. Denying an employee equal access to a common restroom corresponding to the employee's gender identity. Harassing an employee because of gender transition, such as by intentionally and persistently failing to use the name and gender pronoun that corresponds to the gender identity with which the employee identifies, and which the employee has communicated to management and employees. Denying an employee a promotion because he is gay or straight, so it goes both ways, right? Discriminating in terms, conditions, or privileges of employment, such as providing a lower salary to an employee because of sexual orientation, or denying spousal health insurance benefits to a female employee because her legal spouse is a woman, while providing spousal health insurance to a male employee whose legal spouse is a woman. Also harassing an employee because of their sexual orientation, for example, by derogatory terms, sexually oriented comments, or disparaging remarks for associating with a person of the same or opposite sex. Discriminating against or harassing an employee because of their sexual orientation or gender identity, in combination with another lawful reason, for example, on the basis of their being transgender and on the basis of their race. It's like if they were a black transgender, so that's even more. It's like it doubles the discrimination, right? Or their sexual orientation and their disability. Again, it kind of doubles all of that up, and this is all basis for discrimination claims in the workplace. So let's look at the Civil Rights Act of 1991. So still Title VII. It only allowed damages for back pay. So Title VII initially only allowed damages for back pay. The Act of 1991 enables individuals to receive both punitive damages, which are damages that punish the defendants, and compensatory damages for financial or psychological harm. The 1991 law extended the possibility of individuals collecting damages related to sex, religious, or disability-related discrimination. Some organizations had developed a policy of adjusting scores on employment tests where a certain percentage of a protected class would be hired. This amendment to Title VII specifically prohibits these quotas, which are, again, diversity goals to increase the number of protected class members in a workforce. But we're going to get to what can employers do to then increase diversity in their workplace. You couldn't set quotas, but there are other things that can be done. So age discrimination in Employment Act of 1967. So this is the first. We're going to look at a bunch of major employment-related legislation. So this act protects employees and job applicants that are 40 years and older from discrimination as it applies to hiring, firing, promotion, layoffs, training, assignments, and benefits. So this is from the idea of companies laying off or firing older employees that have been there for a long time, that had, established seniority, have pays have increased because they've been there for a long time. And they found like if they got rid of the older employees, they could hire young people that, were just brand new, young graduates or just high school graduates into the company and train them up for maybe like half as much, right? So a lot cheaper. So companies were discriminating against older employees just to cut their cost of employment. The Older Workers Benefit Protection Act of 1990. This act amended the Age Discrimination and Employment Act, and its goal was to ensure that older workers' employee benefits were protected and that organizations provide the same benefits to both younger and older workers. Of course, then the older workers might use those benefits more because they're older, right? And so trying to prevent discrimination based on that. The Equal Pay Act of 1963. This act, amended by the Fair Labor Standards Act, enforced by the U.S. Department of Labor, mandates that all employers award pay fairly to both genders if it is determined their jobs have equal responsibilities and require the same skill. So, for example, in healthcare, if you are a new graduate RN and you are applying to a job in med-surg, it should not matter if you are a male or a female, your starting salary should be the same because you're bringing the same kind of sets of skills, brand new, right, to the workplace. The Pregnancy Discrimination Act of 1978 is an amendment to Title VII of the Civil Rights Act of 1964, and this act protects female employees who are discriminated against based on pregnancy-related conditions, which also constitutes illegal sex discrimination. So it's not even being fired for being pregnant. That actually happened to me like way back, and I didn't even know that it was illegal. But yes, I was let go because I was pregnant. Yeah. Some executive orders. This is talking about affirmative action. So an affirmative action plan is a plan that outlines the employer's standard on recruitment and hiring to increase the diversity of the company's workforce. The plan is created to correct past discrimination in a company. So potential employees must first qualify for the job, right? Employers cannot set quotas, but they can develop strategies to encourage applications from diverse candidates. So an employer who develops an affirmative action plan has to perform an analysis of the demographics of the current workforce compared to the demographics of the eligible pool of qualified applicants. And so the idea is your workforce should reflect your applicants, right? And so this is where, let's just use, we know like in STEM fields, we're trying to increase diversity. And that, like blacks tend to be blacks and browns tend to be underrepresented in STEM fields, and we're trying to increase that. And part of the reason they were underrepresented is because the eligible pool of qualified applicants didn't reflect them either, right? So that goes to increasing access to education and giving resources and things so that we have more of them coming out of, with degrees in the STEM field so that they can fill those positions in the workforce. That's just one example. The American with Disabilities Act of 1990, or the ADA, it focuses on individuals who are considered disabled in the workplace. And it states that employment discrimination is prohibited against individuals with disabilities who can perform essential functions of a job with or without reasonable accommodation. So let's unpack what that means. So, essential functions are job duties that must be performed to be a satisfactory employee. So I will give you an example of an essential function in the job that I have or had, especially when I was working in hospitals. So I was a medical lab scientist or a lab tech. And one of the essential functions in our job is sight, is to be able to see. Because we are working with instruments, we are working with pipetting, we are looking on the microscopes, we are evaluating things, so we have to be able to see things. And so, unfortunately, a blind person does not meet the essential functions of being a lab tech. Now, there are other things that we can accommodate for, but blindness is not one of them. A reasonable accommodation refers to employers that take reasonable action to accommodate a disabled individual, such as providing a special computer equipment or furniture to accommodate a physical limitation. The reasonable accommodation should not cause undue financial hardship to the employer. So it should be pretty easy to accommodate. And it may cost a little bit, but it shouldn't be, trying to, build an entire wing in a hospital or something like that, right? Which is kind of crazy. Okay, Occupational Safety and Health Act of 1970. It was passed to ensure that employers have a general duty to provide a safe and healthy work environment for their employees. And this is for all of the industry, right? And this is very important for the healthcare industry because of our potential exposures to bacteria, viruses, and contaminated fluids. Therefore, under OSHA, your hospital and clinic employers have to provide their employees with personal protective equipment and all of the things that they need to do their jobs safely. The Employee Retirement Income Security Act of 1974, or ERISA, regulates pension and benefits plans for employees, including medical and disability benefits. So it protects employees because it forbids employers from firing an employee so that they cannot collect under their medical coverage. So like because they get sick or they're diagnosed with a cancer, there's something that they're going to cost a lot to the health plan, you can't fire them because of that. The Consolidated Omnibus Budget Reconciliation Act of 1986, also known as COBRA. It was an amendment to ERISA. It was passed to protect employees who lost or changed employers so they could keep their health insurance if they paid 102% of the full premium. So this act was passed because at the time people were afraid to change jobs, which resulted in the concept of job lock. They were afraid that they were going to lose their benefits and lose their healthcare coverage, etc. So they would stay in the same job at the same company. Of course, 102% of the full premium, that's a lot. You have to be able to afford it. And for most healthcare benefits, a portion of the premiums were paid by the employee and a portion was paid by the employer. So you can keep your benefits, you just have to pay the whole bill for them. But it is available to you and it should be offered to you. And then we've already mentioned this one, but the Health Insurance Portability and Affordability Act of 1996, or HIPAA, was passed to promote patient information and confidentiality in secure environments. It was fully implemented in 2003. The amount of health information released is completely controlled by the consumer. This is the first federal legislation that provides an in-depth protection to consumers about their health information. So you get to decide who can look at your medical records, billing information, and all of that. So if your spouse or your kid or whatever, to be able to make decisions and look at things on your behalf, you have to say so. There's a form usually you have to fill out and designate who you allow to have access to your records. The Health Information Technology for Economic and Clinical Health Act of 2009, which is also known as the HITECH Act. It was effective in September of 2009. It amended HIPAA by requiring stricter notification protocols for breach of any patient information. New rules apply to any associates of the health plan, so anybody related to the health plan that might have gotten access to the health information. And it also increased HIPAA's civil and criminal penalties for violating consumer privacy regarding their health information. And so this can happen like if a record is breached, somebody has gone into and looked up results on a relative or acquaintance's record, and they come across some protected information, and of course then they divulge it, they talk about it, and then it's known. And they're like, well, how did they know? And then they go see their digital footprint that they were in that chart, and they weren't authorized to be in that chart and had no business being in that chart. And even if you do it, you're in that chart because of your job, you still cannot tell people what you were doing at work or who you saw, who you cared for, because that is protected information. So you have to be very careful, because you could then find yourself in a felony for violating HIPAA. The Family Medical Leave Act of 1993, also known as FMLA, requires employers with 50 or more employees that live within a 75-mile radius, who work for more than 25 hours per week, and who have been employed for more than 1 year, to provide up to 12 work weeks of unpaid leave during any 12-month period for employees to provide care for a family member or for themselves. Again, this is legally, it's unpaid leave. Some other countries around the world do give people paid leave. This doesn't mean that you can't use your paid time off to cover this leave if you have accumulated such, or use disability benefits or something like that. The Genetic Information Non-Discrimination Act of 2008 prohibits U.S. insurance companies and employers from discriminating based on information derived from genetic tests. This is especially with 23andMe and Ancestry type testing that are widely available. It forbids insurance companies from discriminating through reduced coverage or through price increases. It also prohibits employers from making adverse employment decisions based on a person's genetic code. So let's just use one easy example. If you did a test and they saw that you had the BRCA gene, so the breast cancer gene, that doesn't mean that you specifically are going to get breast cancer. But if a health insurance company saw that and decided to charge you more or to deny you coverage, that would violate this act. Or if an employer decided not to hire you because you might then you might get cancer, then that again would be a violation of this act. The Mental Health Parity Act of 2008 requires equality or parity of lifetime and annual limits of healthcare insurance reimbursements for mental health care. So it was basically saying that if you provide mental health benefits, they must be reimbursed to kind of the same rate as medical benefits, right? But unfortunately, it did not require employees to even first offer mental health coverage. This is only for employers that already were offering mental health coverage. It also did not impose limits on deductibles or co-insurance payments, and it did not cover substance abuse. It spurred several states to implement their own parity legislation, and it amends the Mental Health Parity Act of 1996 to include also substance abuse treatment as part of group plans. And lastly, the Lilly Ledbetter Fair Pay Act of 2009 is an amendment to Title VII of the Civil Rights Act of 1964, which also applies to claims under the Age Discrimination Act of 1967 and the Americans with Disabilities Act of 1990. And this provides for protection for unlawful employment practices related to compensation discrimination. So again, looking at equal skills, equal experience for the same job, there shouldn't be any discrimination across all kinds of different categories, whether it's via sex, male and female, which is historically males have been paid more than females because they were perceived as being the breadwinners, and females were just contributing a little bit to the household. Of course, these were older ideas. So now, same job, same pay, no matter who you are. And same thing with discrimination, black, white, or brown, whatever. None of that is proper. So again, it is unlawful to have compensation discrimination, basically. Okay, so that was the last of the major employment-related legislation, and I have one more installment to this healthcare law chapter that will be coming up next.